Good morning and welcome to PV Legal's daily newsletter. Can a photocopy of a handwritten diary, with no supporting evidence, be enough to drag the CEO of India's largest private sector bank into a criminal investigation? The Bombay High Court, in a landmark ruling pronounced on the 5th of May 2026, gave a definitive answer: absolutely not. The judgment is reported as Sashidhar Jagdishan v. State of Maharashtra, decided by a division bench of Justice M.S. Karnik and Justice N.R. Borkar of the Bombay High Court. At its core, this case asks, when does the criminal law cross the line from being a tool of justice to becoming a weapon of harassment? The story begins in 1995. A company called Messrs Splendor Gems Limited, owned by the Mehta family of Lilavati Hospital in Mumbai, took loans from a consortium of banks including HDFC Bank. The family defaulted. After years of litigation, the Debt Recovery Tribunal issued a recovery certificate in favor of HDFC Bank in 2004 for over 14 crore rupees. That amount, with interest, had ballooned to over 65 crore rupees by 2025. Despite this, the borrower's family fought the recovery at every stage. For nearly 2 decades, the DRT itself, at one point, issued arrest warrants against the guarantors and remarked, in its own words, as enough is enough. Meanwhile, following a Supreme Court order, new trustees took charge of the Lilavati Kirtlal Mehta Medical Trust. When the patriarch, Mr. Kishore Mehta, passed away in May 2024, his heirs, particularly the complainant Prashant Mehta, attributed the death to pressure from the bank's recovery proceedings. What followed was a cascade of complaints to the RBI, the Ministry of Finance, the Maharashtra Minorities Commission, and multiple criminal courts. Every single one was either rejected as meritless or quashed as vexatious. And yet, on the basis of nothing more than a photocopy of a handwritten cash diary claiming a payment of 2 crore 5 lakh rupees to the HDFC Bank CEO, the complainant managed to persuade a magistrate to direct the registration of a fresh FIR. 3 issues came before the High Court. First, should the court exercise its inherent powers under Section 5 and 28 of the BNSS to quash the FIR at this early stage? Second, do the allegations disclose the essential ingredients of criminal breach of trust and cheating under Sections 406, 409, and 420 of the IPC? And third, does Section 175 subsection 3 of the BNSS give any complainant a mechanical right to get an FIR registered even when prior identical complaints have been rejected? The High Court answered all 3 in favor of the petitioners. Relying on the Supreme Court's celebrated judgment in State of Haryana versus Bhajan Lal and the recent ruling in Imran Pratapgarhi versus State of Gujarat, a 2026 Supreme Court decision, the bench held that there is no blanket rule preventing interference at the nascent stage of investigation. When a complaint is manifestly mala fide, the court must step in. The bench was direct. In our view, the complaint is nothing but a counterblast to the recovery proceedings. The court also held that a photocopy of an unverified diary without any corroborating material was simply not sufficient to constitute the foundation for a criminal investigation. The allegations, even taken at face value, did not disclose any entrustment or dishonest inducement, the essential ingredients of the offenses charged. The magistrate's order was quashed. Both FIRs were set aside insofar as the bank officials and Phoenix ARC directors were concerned. What this judgment tells practitioners and businesses is this: legitimate recovery proceedings are legally protected. Filing a criminal complaint to stall debt recovery with fabricated or unverified documents will not survive judicial scrutiny. Courts will look at the totality of the background. A complaint must be bona fide, not a litigation tactic. For the full legal analysis of this judgment, subscribe to PV Legal's daily newsletter. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant, stay alert, stay compliant. Thank you for watching. Good day.